In practice, real estate licensees have, under the law, enormous exposure to liability. Some brokers purchase what is known as errors and omissions, E&O, insurance for their firms. Similar to malpractice insurance in the medical and legal fields, E&O policies cover liability for errors and negligence in the usual listing and selling activities of a real estate office. Individual salespersons might also be insured. Licensing laws in several states now require E&O insurance for their brokers and, in some cases, for individual salespersons as well. However, no insurance policy will protect a licensee from a lawsuit or prosecution arising from criminal acts. Insurance companies normally exclude coverage for violation of civil rights and antitrust laws as well. Remember that saying, the condition of property is as is, does not preclude provisions already in the contract. As is, sellers sometimes complain because they are still expected to have plumbing, electrical, and mechanical systems, plus all appliances in working order as is often specified in the contract. If sellers truly mean as is, they must cross out any printed provisions existing in the contract that relate to the condition of systems and appliances. Under the agency statutes of some states, real estate agents are specifically prohibited from making offers of sub-agency through an MLS. Licensees should be aware of their state laws regarding sub-agency. Licensees are urged to obtain advice from state and local authorities responsible for environmental regulation whenever the following conditions may be present: toxic waste dumping, underground storage tanks, contaminated soil or water, nearby chemical or nuclear facilities, and health hazards such as radon, asbestos, and lead paint. Brokers and salespersons and any other staff members must always be careful about the statements they make. They must be sure that the customer understands whether the statement is an opinion or a fact. Statements of opinion are permissible only as long as they are offered as opinions and without any intention to deceive. Statements of fact, however, must be accurate. Exaggeration of a property's benefits is called puffing. While puffing is legal, licensees must ensure that none of their statements can be interpreted as fraudulent. Fraud is the intentional misrepresentation of a material fact in such a way as to harm or take advantage of another person. That includes not only making false statements about a property, but also intentionally concealing or failing to disclose important facts. The misrepresentation or omission does not have to be intentional to result in broker liability. A negligent misrepresentation occurs when the broker should have known that a statement about a material fact was false. The fact that the broker may actually be ignorant about the issue is no excuse. If the buyer relies on the broker's statements, the broker is liable for any damages that result. Similarly, if a broker accidentally fails to perform some act, for instance, if he or she forgets to deliver a counter offer, the broker may be liable for damages that result from such a negligent omission. At each step in a real estate transaction, the broker should advise the parties to secure legal counsel to protect their interests. Although real estate brokers and salespersons may bring buyers and sellers together, and in most states may fill in pre-printed blank purchase agreement forms, only an attorney may offer legal advice or prepare legal documents. Licensees who are not attorneys are prohibited from practicing law. To be a procuring cause, the broker must have started a chain of events that resulted in a sale. A ready, willing, and able buyer is one prepared to buy on the seller's terms and ready to complete the transaction. Antitrust violations include price fixing, group boycotting, allocation of customers, allocation of markets, and tie-in agreements.